a little bit into another touchy subject, which, as far as I can remember, has always been a contentious issue, which is the old back-to-back payments. So we often see this in contracts where, either the party doesn't read the contract and he signs up to it, or he reads it, objects, and then gets forced to sign up to it, and or gets convinced, don't worry, there's no issue, and then 2 years later there's an issue. So how can people safeguard their interest with the back-to-back?
Yeah, absolutely.
First, I'll speak on the legal side.
Yeah.
Okay. The back-to-back clauses in other jurisdictions is not usually it's not permitted, right? It's against the law. Here in the UAE it is permitted. And then here in the UAE also courts, they don't make a difference between if it's paid when paid or paid if paid. They see it as one. So that's just gives some context in terms of the legal set. How the courts have interpreted back-to-back provisions here is very tricky. It depends on the circumstances it's being applied, as well as, more importantly, how the clause is actually drafted. And it also depends on the emirate too. The Dubai courts versus the Abu Dhabi courts see the back-to-back provisions differently depending on the circumstances. So I'll give you an example, like termination. If the contract was terminated early for an event that was beyond the real party's reasonable control, the two Emirates court systems see that how the back-to-back provision applies differently. You'll get two different types of rulings there. But in general, back-to-back provisions, if the subcontractor has finished its works and has gotten TOC or some type of handover certificate from the main contractor, and the project is still ongoing, the main contractor has finished the main works, more than likely the subcontractor, main contractor can say that back-to-back provision is still in effect, and I'm not going to pay you until I get paid from the employer. The subcontractor can't do anything.
Yeah, I mean, the things that I would add to that, I mean, what you have to look at, it's, they will very often use the back-to-back provision to avoid payment to a subcontractor. But you have to look at, have the actual subcontract works been completed and handed over and been accepted, maybe accepted by the employer or the employer's consultant. And it could be that the contractor is withholding money. Sure, he hasn't been paid, but maybe he has been paid the elements of his payment which relate to the subcontract. So a simple statement of "I haven't been paid, therefore I'm not paying you." You have to look a bit beyond that and see. And I've seen that tack taken when, in fact, when you look into it and you dig into it, you find that actually the payments the main contractors received do relate to the subcontractor's work, and the subcontractor's work has been certified 100% by the consultant, by the engineer. So you have to look a bit.
I think again it stresses the importance of reading your contract, understanding what you signed up to, and taking advice if necessary, if needed. We have seen instances where subcontractors, subconsultants even, have started working on a project without actually realizing the terms and conditions.
Yeah.
And then through the process, they come to the point where they need to sign up. Maybe they started on the basis of an LPO or a letter of intent, for example, when due to the speed they had to start, but then they find that clause is there. So, and then it becomes an issue. So I think one of the things that we really want to stress is that you have to sign up a contract at the very start and be clear what you've signed up